We will start by 7:5. Good evening, everyone. I'm Shrutika with my co-host Tanish, and we are truly delighted to be your host for today's important and thought-provoking webinar on Laws Without Borders: Global Response to Borderless Crime. This webinar is being organized by Naksh Foundation under its Cyber Awareness Initiative, the CyberShield project. Naksh Foundation is a dedicated non-profit organization working towards education, empowerment, and awareness among youth. Through the CyberShield project, the Foundation spreads awareness about cyber threats, digital safety, and legal frameworks that protect individuals in today's interconnected world. By conducting workshops, webinars, and outreach programs, this initiative empowers students, young professionals, and communities to adopt safer online practices and build stronger resilience against cyber risk. In today's globalized era, crimes no longer remain confined within national boundaries. From cybercrimes to money laundering, terrorism to human trafficking, we face challenges that transcend borders and demand collective global action. This theme highlights the urgent need for international cooperation, organized laws, and stronger enforcement mechanisms to ensure justice in a world without borders. Before we begin, a gentle reminder to all the participants: kindly keep your microphone must be muted, and to avoid background noise, please keep your video turned off unless you are in a proper setting. If you have any questions during the session, drop them in the chat box. They will be addressed during the Q&A session at the end. Thank you for your cooperation. Now let us move to the highlight of today's session. It is my privilege to introduce our distinguished speaker for today, Mr. Blessin M. Mr. Blessin is an advocate and legal consultant at NABARD, where he provides legal advice on banking law, financial regulation, and institutional policy framework. His expertise spans across banking law, contract negotiation, insolvency proceedings, SARFAESI, and cross-border financial regulations, while also contributing to institutional governance and risk mitigation. He holds an LLB in intellectual property law from IIT Kharagpur and an LLM in human rights from NLSIU, Bengaluru, where his research focused on the right to privacy. A UGC NET or JRF scholar, he has combined practice with academia, serving as an academic tutor and trip fellow at OP Jindal University, teaching and researching on intellectual property, human rights, and gender justice. Beyond practice, Mr. Blesson has authored several books, published numerous articles, and mentored more than 50 junior advocates. He also brings over 50 years of experience mentoring civil service aspirants and law students. His career includes significant roles at the UCO Bank and NABARD, managing high value recoveries, regulatory compliance, and litigation strategy. With such diverse expertise, he will guide us today on some very important aspects of borderless crimes, including understanding borderless crimes in a globalized world, technological innovations transforming transnational crime prevention, international legal frameworks and institutions, mechanisms for cross-border cooperation and enforcement, legal and ethical challenges in global crime engagement. We are truly honored to have you with us today, sir. Without further delay, I now invite you to take over the session and share your valuable insights with us. Over to you, sir.
Good evening, all. Thanks for this introduction. This is a very contemporary topic in law, that is borderless crimes. How does borderless crime affect countries? How does borderless crime affect various citizens or lots of other people these days in the day of AI or computers, interconnections, and etc.? We need to know about how the international community has responded to these crimes, which is connected in a different area. So before I begin, we need to understand what is borderless crime. When I say borderless crime, we all know we live in an international Westphalian society where there are a lot of countries, they have borders and they have their own citizens, nationalities, jurisdictions, etc. So all these come into play. Before that, you need to understand what is a borderless crime. There are various definitions, but one such is from the United Nations Convention on Transnational Organized Crime, that is UNTOSO, which says that it is committed in more than one crime. It is committed in more than one country. That is, the effect of the crime is felt in different countries. And not necessarily the perpetrator must have been situated in the particular country. Say, for instance, the perpetrator might be sitting in a country like Serbia or Brazil, and he might be giving an security cyber attack on United States, UK, uh, Russia, India. So various countries, the effect will be on various countries, and there will not be one particular perpetrator. The perpetrators can be an organized crime gang situated in multiple areas. Feel free to ask questions in between and stop me. And in case if you're not getting what I'm saying, you can always raise a hand, and whatever it is, we can have an interactive session as well. So before this, I just want you to envisage a situation. Say for instance, a perpetrator sitting in a country like Serbia, for instance. Let's say he's sitting in a country like Serbia, and his nationality is Russian, and he is organizing an attack, a cyber attack on computers situated in Germany, or a computer situated in Germany. And let's say it's a German bank. The bank's customers are from various nationalities. Let's say there are Indians, Italians, French, US, UK. So there's various nationalities. And the perpetrators are sitting in Serbia. Their nationality is in, is a Russian nationality. Or for instance, they have a gang leader who is holidaying in Italy, and they organize an AI-based sophisticated phishing attack targeting computers in Germany. And the intended effect has serious data breach consequences on different nationalities like Indians, Italians, French, and other nationalities. So how does the global community respond to such situation? This is the most important question. And if you look at the traditional international law, which was set in Westphalian form of system in 1648, the traditional international law is based on sovereignty of a country and jurisdiction. Like, say, for instance, a country has a,
Sorry for disturbing, sir. Should we present the PPT, sir?
that's okay. It's not the PPT is not that essential. The students can just follow me and go through it. But if you want, you can keep it as a side way. It's not very mandatory that PPT should be there on the screen.
Okay, sir.
So like I said, the traditional idea of international system works on the principles of sovereignty and jurisdiction. It's like when I say sovereignty, a country is sovereign, which means that within the country, the resources, everything is controlled by the country, the government of the country. And jurisdiction, when I say jurisdiction, there are various things. One is the ability to create laws within their country, and the ability to impose laws within the country. And also the country has courts, whether the courts can particularly try these laws or not. So these are the traditional way of international law. But this traditional way of international law doesn't answer to a situation like this, where a different nationality sitting in a different jurisdiction and targeting another different country. So how does the international law respond to such situation? And many of us believe that this is a very recent phenomenon. This computers, this other things are very recent. But if you look at it, the concept, this has been running for more than 200 years. There's 200 years of case laws that has been developed into tackling such situations. For instance, there was this Lockerbie bombing incident. What happened was Libyan nationals planned a bomb attack in an aircraft, and the aircraft was flying over Scotland, and at which point it burst. And now, if you look at Scotland, Scotland had no connection over it. Scotland had no connection except that the aircraft was flying over the territory of the Scotland. But if you look at the perpetrators, they were Libyan nationals. They planned this crime in a different country. And despite that, the courts recognized Scotland's ability to try this case based on a concept called the territoriality. So the first thing you have to understand from the jurisdiction perspective is territory. Say, for instance, if anything happens within your territory, the country can actually take action. So that's as simple as that. So in my example, like I said, perpetrators from Serbia, who's a Russian national, organizing a cyber attack in Germany. Now, even though those people who is not a national of Germany, the Germany can take action based on this international law principle called territoriality, because the intended effect is in Germany. So the intended effect is in Germany, so they can actually take action against the people in Serbia or Russian national. But the question here is, like I said, when you are talking about jurisdiction on sovereignty, there are two essential principles. That is, one is the ability of the country to make laws and the ability of the country to enforce the laws. Now, the Russian national is sitting in Serbia. Without the consent and without the cooperation of Serbia, the Germany cannot apprehend the particular individual. Now, that is where the international organizations like Interpol or the United Nations conventions and other mutual treaty mechanisms come into picture. And one such mechanism is, we all know the idea of extradition. So the extradition means a country which is affected by a crime will request the country where the perpetrators is located, and will they ask them to extradite him to the particular country to try. And there are various issues with regard to extradition, like, for instance, the country may not be cooperative to send the national, or there are principles in extradition. There are principles in extradition, like one is that double criminality. That is, if I have to extradite a person, the crime, the intended crime, say for instance, if the person has committed murder, it should also be a crime in my country. Say for instance, India is asking for a Pakistani national for a crime of murder. Until and unless murder is a crime in Pakistan, they cannot be extradited. That is one thing. That is the principle of double criminality. And other is substance. The substance, when I say substance, you cannot extradite this Pakistani national for a crime of murder and then try him for something like money laundering or theft or any other things. You have to try him only for what, I'll get back to you, Anuj. You have to try for only for what crime you asked the country. So these are the issues. Say for instance, if Serbia recognize a cyber attack as a minor computer issue, then there's going to be a problem in extradition. And if Serbia is saying that, or if Serbia thinks that we will try this individual here, and there's going to be issue with extradition. And one more thing, extradition mostly happens based on extradition treaty. And in case if there is no extradition treaty, then this couldn't happen. This will not be possible. Yes, concept of speciality and dual criminality. So this will not be possible. So that is where this United Nations treaties or United Nations conventions, like I said, UNTOC comes into picture, or mutual legal assistance, all those things come into picture. So when you understand this concept, you have to understand two important things in international law. how does jurisdiction work, and how does the principles of sovereignty work. And based on this, how the international law has responded to crimes which has affected multiple nations or multiple countries. Number one, like I said, in terms of jurisdiction, territory is very important. Like I say that if a crime is intending to be affected in a particular territory, there's no question asked. The state can, in fact, try them. This is the famous. Uh, this is the famous international law concept developed from an SS Lotus case. For anybody who is an international law student, SS Lotus is a very landmark case where in high seas, two ships collided, uh, and it collided, and actually a Turkish national was affected. And the Turkey arrested the French captain of the ship based on this principle, saying that it actually affected one of my individuals, and France actually opposed this, saying that it is only the flag state of the ship that would have jurisdiction. Whether the Turkey has jurisdiction or not was the big question. Whether in high seas, because like you said, high seas is not a particular territory. And when I say when there is no territory, whose territory is it? And there is a ships colliding, and as Turkish national was in fact affected, and whether Turkey can in fact arrest French captain or not is a big question. And this is where the next concept in jurisdiction comes in, that is the nationality principle. That is, one is territoriality, that is, if the intended effect is in my territory, like a cyber attack from Serbia happening in German territory, no questions, Germany can in fact, based on the principle of territory, can in fact ask for the extradition of the Serbian or Russian nationals. Next is, if it affects my nationals, then again the particular perpetrators can be tried. So this is where like the issues get a little bit wider. In my example, what I gave is the Serbian national starting a cyber attack in a German bank, and the German bank had customers of various nationalities like India, Italy, France, UK. Now, what would happen if every nationality claims we have jurisdiction, we will try? What is the result? Let's take the example of the recent crash, Air India crash in Ahmedabad, where various nationalities were involved. So these are other aspects, but usually what happens is that who had the most substantial effect, that particular country can in fact request. But the idea here is that this is how different countries can actually bring the perpetrators to justice. So the second important principle in terms of jurisdiction is nationality. One is territoriality and the next is nationality. The nationality has two things. One is active and passive. What is active? Active in the sense, if the perpetrator is a particular national, say I said it is a Russian national, Russia can directly ask, bring it to us, it's a crime in our country, we will try him. This is active nationality theory. That is, any state whose individual is actively involved in the crime, they can be tried by that particular state. Next is the passive nationality theory. What is passive nationality theory? Passive nationality theory means nothing but the victims are of a particular state. So this attack, our state citizens are victims, so we have to try him. Now, whether only this territoriality and nationality is the only thing, or what about the other things? There is another principle that is called as, which is actually quite controversial, that is the protective personality principle. That is, a state can say that, look, we have to protect our citizens, so hence we are apprehending him. And actually this can be quite political, because this can be misused. This particular principle can in fact be misused. But this is also another theory where the state can in fact bring the perpetrators for justice. And another important theory is, which is actually developed by the customary law, that is the universality. What is universality? Now, can anybody tell me about the just cause principles or peremptory norms in international law? Well, okay, these are higher norms in international law where no derogation can take place, like torture, genocide, war crimes. And if you look at the issue in Myanmar, where a particular community has been accused of genocide, then such higher just cause principle, there is no need for anything. There's no need for your territory to be affected. There is no need for your national to be affected, and there is no need for your you need to protect anything. Based on the concept of universality, that is, these are considered as crimes against humanity. Genocide or torture convention, any state can bring the perpetrators to justice. Now, these are the principles that is developed over the period of time on how to tackle this borderless crimes. Basically, like I said, the fundamental Westphalian idea of international law is sovereignty and domestic jurisdiction. And what is domestic jurisdiction? We all know this principle called non-interference in others' internal affairs. Until and unless it is serious breach of human rights, no country can interfere in the others' internal affairs. Now, this has all this again, like I said, the human rights aspect has come into big picture. Now, like I said, in the example, this Russian national is in Serbia conducting a coordinated attack on German bank affecting various nationals. Now, Germany is the country that has identified this individual, and they identified that this person is in Serbia, and they've also identified the gang. The leader of this gang is holidaying in Brazil. Now, what is this? What is the solution? Now they have to ask with Brazil. They have to check whether they have any extradition treaty with Brazil or not. So these are all the aspects. These are all the practical aspects. But the bigger and larger question is how to do it in practice. This can never happen without cooperation, and that is where the United Nations comes into picture. That is where the principles of committee comes into picture. That is where the treaty obligations come into picture. And one more thing, we should not forget the idea of human rights in this. Germany, if it is known to abuse its criminals or prisoners, then their extradition can be validly rejected by Brazil. So the another aspect that you have to understand here is that the human rights principles, the fundamentally everybody should have should be given a right to fair trial. We all know to the two major human rights documents as ICCPR and ICACR, especially the civil and political rights, gives various fundamental protections, which are mostly like most of which has become a just cause principle. Like if the Russian national or if the leader of the gang sitting in Brazil can convince the Brazil that I would not be given a fair trial in Germany, then again he can be shielded. And the another aspect in terms of extradition is political issues. Now, if you are being tried for a politically charged issue, then again extradition can be validly stopped. The Brazil can say that this is a political issue. You show us the connection. There is no proper connection, so they can be stopped. And apart from these things, these are the fundamental substantive issues. Apart from these things, there are procedural issues involved. How cooperative Serbia is going to be to the Germany? You cannot bring a person based on just by accusation saying that he sat in your territory and he orchestrated this attack. You have to collect evidence. And in terms of collecting evidence, it means that you have to allow the German prosecutors or the German investigators into your into your nation, and allow them to, collect evidence. And this is again something that is very that is fundamentally against international principle. Like, it affects the sovereignty. Any country can say, like, how can we allow your prosecutors to come in or your investigators to come in and collect evidence in our country? We will do that. So these are the issues that is practically in front of us in bringing such perpetrators to justice. Now, I think I can take some questions so far, so that if there is any doubt, I can clarify it.
Sir, may I ask one question?
Yeah.
Sir, I want to ask that, like, Russia-Ukraine war is going on, and there is a lot of cyber attacks on Russia. Russia is a victim country now because from the NATO nations and in cyber attacks, and from America there are several hackers and cyber attacks were doing and going on in Russia to flatten their economy or ruin their economy and on their banks, hospitals. So what can Russia be doing, like International Court of Justice and ICC, for taking the defense against them?
Okay, so there's a lot of things into this question. I would not want to go into the real picture right now, but your question says that Russia is actually involved in a war with Ukraine, and so which means that the fundamental principles will not, fundamental principles of normal time will not be applicable. So most of the things will be applicable as the humanitarian law. Despite that, if Russia wants to bring the perpetrators to ICJ forum or any forum, first thing is Russia has to respect the ICJ or United Nations systems, and I don't think so that is the major issue. ICJ is quite it's actually quite broad in exercising its jurisdiction. So like I said, Russia has to take the case to the ICJ, or more depends on who is perpetrating the attack. Like, I would say, after the Rome Convention in ICC, there is also individual responsibility. So if the Russia can identify any individuals within a country who is doing they can actually ask the particular country to, like I said, extradite them if they have an extradition treaty with them, or there is this thing called luring. So what is this? This is an international concept called entrapment. Say, for instance, instead of asking the country to extradite them or send them, the Russian, or this has actually happened. The intelligence agencies can lure the person to come into their territory, and in that case, actually, what the court has said that if there is no massive human rights violation, and if his human rights are not violated, it does not matter how you have brought them into the territory, as long as if next procedures is going to be fair and procedurally well, so they can be tried. So the various things, the straight answer for your question is that if the Russia feels that the attack is coming from USA, the first thing is to talk with the USA, or if the attack is coming from UK, the first thing is to talk to the UK or USA through diplomatic channels and to whatever treaties they have and ask them to stop it. And in case if that is not happening, they can actually move to ICJ and try and get justice in favor, or this is that. But definitely can Russia can actually try those individuals if they can prove that a substantial effect is actually happening in their territory.
Thank you, sir. Thank you.
Yeah. So any other doubt with regard to jurisdiction, or how there is a conflict between the fundamental Westphalian idea of international law, that is sovereignty and domestic jurisdiction, and the idea that has evolved? I saw a lot of people raise their hands. Okay, I can see a lot of questions. Is it ethical for one country to conduct counter hacking operations on servers located in another country? Like I said, the question of ethics doesn't come in. Ethics is ethics, morals. All these are very wide concepts. But when you talk about law, the only justified method in terms of counter attacking another nation is the idea of self defense. That is the only justification. No way you can attack another country under international law. This is absolutely no. International law will not allow you to attack another country. Forget about ethics or anything. Even if my country's systems are affected or anything, you have to use the normal diplomatic and other channels. You cannot attack them until and unless a single exception is there, that is self-defense. And you might ask, all this question, all this wars that is really happening right now, that is the Israel-Palestine issue or the Russian-Ukraine issue or any other wars, this is justified on the principle of self-defense. So if you have self-defense, then you can actually do it. It can either be a counter hacking operations, or it can even be a nuclear attack. Unfortunately, many believe that nuclear attack is against the principles of international law, but the ICJ or nobody has said that a nuclear deterrent or a nuclear attack is completely against international law. That is the unruly horse. The self-defense is a very unruly horse, because, like I said, I can go on attack any small country and say, look, they have a terrorist thing, or they have this, etc., and I'm doing it for my self-defense. So yeah, but these are all developing jurisprudence in international law. How do diplomatic relations affect the handling of the border? That is another important question. Like I said, we might have all these principles, the principles of protective or the principles of passive nationality or everything, or you can also say that I want to try them, I want to do them. But diplomatic relations are very important. Like I said, one concept called entrapment. Say, for instance, one country's intelligence agency lure a person into their country. That would actually affect the diplomatic relations. So it's up to the countries to see to it, to balance to it. And actually, this has happened, especially with regard to United States. The US has been very active in doing this. What they do is, there are cases brought by the United States airline company against airlines operating in Europe. What they said was, these European airlines, that is British Airways or Caledonian, they joined as a cartel and they tried to actually curb competition and try and oust the US aircraft carriers. Now, if you look at this whether US competition law can apply to UK is a big question, because the British Airways or Caledonian Airways who is joining as a cartel are not in any way nationalities of US. They are not registered in US, so it cannot apply. Or it is not in their territory. It is not happening in their territory. Neither the effect is also not in the US territory. It is in the European markets. And only thing is, a company is being affected, and it is also competition law. Whether such action can be taken by courts in US, and the courts in US actually found in favor of the US aircraft, saying that if and any anti-competitive principles affect the economy of the USA, then it is not about crimes or anything. The legislation of the anti-competition of US will apply directly in UK. Now, if you look at this, is a case which favors the US airlines. But what about the diplomatic relations between the UK, between the UK and US? What did UK do? What did the European nations did? They would make counter laws that we will not cooperate with any court orders coming from USA. So that is another thing, maintaining the balance of diplomatic relations with the other aspects of jurisdictional enforcement has to be done. If our national being harassed in foreign nation, like I said, we need to take it through diplomatic channels, and if the diplomacy fails, then take it to ICJ. So these are the basic things. Now we've identified that the borderless crimes, which can serious ramifications in different jurisdictions, is not new to international law. This is happening for the past 200 years, and we have developed methods which is already in place. The next question is cooperation. How do you cooperate? And there is this concept called mutual legal assistance. So through mutual legal assistance, states can actually cooperate. And another important thing is FATF, that's Financial Action Task Forces, which actually targets money laundering. Can any of you explain what is a money laundering? What do you think of money laundering when it comes to your mind? Okay, money laundering is nothing but any proceeds or cash of crimes or which is illegal, using series of methods, actually integrating those money into the proper economy. And what is dangerous with money laundering is these illegal sources of funds actually fuel terrorism and other activities. So again, if you look at this, it is about the countries not only having these legal theories but also following it. And the United Nations or other security councils and other things, say for instance, these days there is a lot of talk about tariffs and sanctions. Economic sanctions is one way where a recalcitrant country which does not obey the international law can be made to obey it, like economic sanctions. And also Security Council can actually take action that is there, usually by sanctions. Very rarely there can actually be military action, but that is going to be very rare, and the procedural aspects is also going to be a big thing. So like I said, the important thing with regard to stopping this borderless crime is having a good treaty-based mechanism, and not only treaty-based mechanism, but also ensuring that the countries actually comply with it. That is the biggest thing, and actually cooperate with it. Cooperating is another important thing. And there are various things. There are various conventions. There is Palmero Convention. There is a convention on cyber attacks. And there are various conventions. Using these conventions and using these methods of mutual legal assistance or extradition treaties, the countries can actually bring the perpetrators to justice. But this is easier said than done, because what is a cyber attack in one country may not be a cyber attack in another country. What is a privacy violation in one country cannot be a privacy violation in another country. And despite all these things, we should also take into the emerging human rights ideas. All these things has to be done in protecting the human rights. I would time and again say that human rights violation is not something that is to be easily taken. It is actually very important to honor the human rights, and if whatever a country do, they have to do it within the human rights. Yes.
Sir, I have one question, sir,
Yeah.
about the transport, sir. While they are coming from, well, the passengers are coming from through flight from Dubai and other places, sir. They are carrying lot of gold and all these things. And when they are coming to our country, India, or any airport here, they are being caught, sir. Like in Samshabad airport or in Delhi airport, like that, sir. So why is it like that, sir? Why they are allowing, and why we have a problem in not allowing them with all that gold or money or whatever it is, sir? What makes them to allow them freely to enter into our country, sir? Why they are leaving them like that as such, and why we have a problem in?
Yes.
Thank you so much, sir, for that incredibly informative and eye opening session. Your insights have given us a new perspective on the urgent global challenges of borderless crimes and the legal framework shaping our collective response. As we draw the curtain of today's session, it's time to extend our heartfelt gratitude. First, a sincere thank you to our speaker, Mr. Blesson M, for not just delivering a lecture, but for bringing clarity to the complex intersection of law, technology, and global justice. Your real world insights and practical perspectives made the session impactful and memorable. Next, a big thank you to all our participants for joining us today. Your presence and engagement makes initiatives like these meaningful. By being here, you are contributing to building a more aware, more resilient, and safer global society. We also extend our gratitude to Naksh Foundation team and CyberShield project for their dedication and effort in making this event possible. From planning and coordination to technical support and moderation, your behind the scene works has been invaluable. Before we close, a quick reminder. Please take a moment to fill our feedback form, which is shared in the chat box. It is mandatory to be eligible for the certificate of the participation, but more importantly, your feedback helps us to improve our future sessions. Once again, thank you all for being part of today's session on Laws Without Borders Global Response to Borderless Crimes. Let us carry forward these insights, spread awareness, and work together to build a safer and just digital world. Take care, stay safe, and we'll see you in the next session. Thank you.
Are there any questions? If there's any question, please raise your hands, and if you're not comfortable, please put it in the chat box.
Yeah, you can actually type it down in the chat box if you want more clarity or if there is any specific issue.
Sir, I want to ask that the Chinese nationals and Chinese nationals are doing cyber activities and cyber crimes in India by getting into in India. So how the China-India relationship affected diplomatic relations and other relations are affected by that. Some Chinese nationals are also arrested by Indian police.
I think it very much depends on how much the Chinese government support these individuals. If the Chinese government does not have any control, or if it is from groups which is uh, operating on their own, uh, then I don't think so. This is going to be a big diplomatic issue between the two countries. Nevertheless, the India will definitely take it because uh, China would have far more control over those perpetrators than India. But the relationship changes wholesome if it is backed by a government, and then I would say a lot of international issues will come into picture because um, like I said, supporting any activities that leads to terrorism, even if it is backed by a state, then that is actually a violation of international law. So it depends on that. If the perpetrators are doing on their own, then I think India would only push through the diplomatic channels to stop these activities. But if it is a state sponsored, then a different set of laws will apply.
Thank you, sir. Thank you.
Yes. And one more important thing is also with regard to the technology that is developing. Like we these days we have developed a lot of technologies, like the spurt of AI, the spurt of large language models, LLMs, and the amount of data that can be the amount of data that can actually be processed in such short term, and more and more issues of privacy and other higher order human rights will come into picture. These are all developing jurisprudence, and today we have just seen very basic idea of how the states can actually interact and curb this crime. But when it comes to actual implementation, a lot more overlap will happen with human rights. How do crimes like human trafficking, money laundering, and online child exploitation demonstrate the need for borderless legal cooperation? Yeah, like I said, human trafficking, money laundering, child exploitation, all these requires multilateral cooperation. This is not only bilateral, because whatever you're talking, these have been already identified for decades by the international laws that needs serious considerations. And there are various conventions, especially human trafficking. This would come into the league of just cause, so the universality principle can apply. And money laundering is another thing, but states have actually brought in a lot of legislations, and this is not a problem in many countries, but nevertheless there are still tax havens, there are still small countries which actually contribute to money laundering. And but what I would say is money laundering is one area where the states have made good progress in terms of actually making substantive laws, but still a lot has to be done. And online child exploitation is that is what I say, that is the most serious thing which will require a lot of efforts, because once it gets online, a lot of things are very murky in this era of this bitcoins, cryptocurrencies, and VPNs. And there's a lot of ways in which a perpetrator can actually mask his identity and encryption and all those things. So this would actually require a coordinated effort, not only in terms of countries, but also technological response has to be there. So the borderless legal cooperation comes more into it. Not only that, if you look at the emerging problems of the world, lot require a multilateral global response. Say, for instance, climate change, or say, for instance, the response to COVID. All these require coordinated multilateral response, and the very idea of border and all these things would actually hamper the humanity's efforts in fighting this. Loan app scam by Chinese in India. Again, like I said, I think I have answered this question. I think India has to take up with the Chinese government and try and stop it at that level. It is more of a diplomacy, and how the government responds, and also India has to make sure that a proper awareness is made. And I think the Indian regulatory agencies, especially the RBI or the other, even the police, are giving a lot of awareness. And in terms of governmental intervention, the government will do this through diplomacy. And what's more important is that it should be seen as a perpetrators, and we cannot, international law, we cannot blame an entire country until unless there are enough evidence to prove that this is being backed by state.
Participants, if there are any more questions, please feel free to ask it.
How can international organization help create a common legal framework for such? Yeah, international, especially United Nations, they have done a wonderful job. Actually, many believe, many have a cynical view of United Nations, but UN as an international organization have actually brought in a lot of draft legislations and brought in a lot of conventions. And this is very important. And even if you look at the lot of treaty making mechanisms, the lot of ideas of treaty making mechanisms are tailored or in the framework to ensure a lot of countries come in and make one coherent legislation or one coherent attack strategy. So international organizations are very, very, very important. They play a crucial role, especially all these multilateral specialized agencies, United Nations or WTOs or FATFs. All these organizations play a very crucial role. And also NGOs and the civil societies, they all play a very, very crucial role. Retaliation, cyber attacks, like I said, it cannot, no attacks can be justified unless and until it is for self-defense. Anuj, like I said, no attack can be justified until and unless it is for self-defense purposes.
Are there any more questions?
Thank you so much, sir, for this valuable session. I would like to ask the participants to please fill out the form if they need so. And if you have already filled the form, you may leave the session. But thank you once again so much to the participants and especially Mr. Blessenem. Thank you, Shrutika, and thank you, the team, for this valuable session.
Can the person be extradited without a treaty? That is very tough. I don't think so. Without an extradition treaty, a person can be extradited until and unless it is serious crimes against humanity. And apart from that, I don't think so. This is possible. But still, nevertheless, there are uh, there are developing jurisprudence. Like I said, UNTOC, they are developing the jurisprudence, and it all depends upon what is the uh, nature of crime, etc. Yeah, murder, rape, these are all serious crimes. There is no doubt about this. But without an extradition treaty, it's always going to be very tough. Extradition treaty is extradition treaty is the most basic, and the courts have actually invalidated a lot of extradition requests, saying it goes against the extradition treaty. So extradition treaty is very important. There is very limited exceptions where this can happen, and like I said, it has to be something that affects the international community as a whole. Other than that, how far serious it is, say it is murder, rape, and all those statutory criminal penal charges, it's going to be tough without an extradition treaty. Do US, India have an extradition treaty? I think that's a very factual question. I have to look into it. I think they probably will have, because most are mostly big democracies. They would have extradition treaty. That's what I'm saying. But it has to be looked into it. What about Vijay Mallya? I think with regard to Vijay Mallya, like I said, you have to see two aspects to it. One is the extradition, the crime, and the next is the human rights aspect to it. If a person can prove that his human rights would be seriously violated in a country, then despite having a valid extradition treaty, despite having everything against the person, he can actually stop his extradition. I'm not actually aware of Vijay Mallya's case, but from other sources, or from whatever sources that I have seen, Vijay Mallya's lawyer might have pressed for a human rights based argument, saying that he might be treated very poorly in Indian prisons, and he might not be given fair trial. And these arguments might have been set up in UK courts, and that is the reason why his extradition is being delayed despite it being signed by the UK government. Like I said, we should not forget the human rights aspect. Like this is a speculation, but my assumption is that the Malaya's lawyers would have raised this with the UK, saying that he may not get a favorable treatment in Indian court system, or in Indian prisons he might not have sufficient human rights protection. How can we see Israel and Palestine war under international law? Up to what extent there is a violation of international law? See, there are two things to this. One is international humanitarian law, which would apply during the international humanitarian law, which would apply during conflict situation. The other is normal international law. Whether there is a violation of international law or not, this is a very blanket question which I would not be able to answer straightforward. But definitely the actions of Israel has been condemned by the international community. I think there is also a warrant against Netanyahu or the Israel, and there is also serious accusation of Israel's method of warfare. Then there's also killings of journalists, And a lot of things are happening. It definitely a lot of violations are happening on the front of international humanitarian law and international law. But this that is up for the courts and others to decide. Like I said, international law runs on the pedestal of cooperation, and unfortunately, the limitation of Security Council. Say, for instance, the Big Five. If any one country supports Israel, then I don't think so much can be done. And unfortunately, that is happening with this conflict. And hopefully, we can see an expansion of the Security Council, which India has been pressing for long. But definitely, there are lots of violations under international law in conflict. Like I said, any war is a violation of international law. No war is justified except for the purpose of self-defense. And even if it is self-defense, the amount of clash that is happening in Israel and Palestine, I think it has exceeded the proportionality requirements.
Are there any more questions? Okay. Thank you, sir, for taking your valuable time and answering all these questions posed by the audience. It was a pleasure hearing you speak, and it definitely would spark a meaningful conversation as well. And we, on behalf of the Naksh Foundation, appreciate you, sir, for accepting to be a honorable speaker. Thank you once again, sir.
Thank you, and thanks for this foundation for giving me this opportunity. Hopefully, we'll have a lot of such sessions. Thank you.
Thank you, sir.